So you're thinking about wadding your contract up, throwing it in the garbage, working on handshakes from now on because you are wondering what good are the contracts? Well, in today's video, we're going to be talking about 4 ways in which your contract is working for you and you might not even realize it. Stick around. Welcome back to Wedding Industry Law. My name is Rob. I am an attorney representing wedding and event industry professionals. And on this video, we're going to be talking about 4 ways that your contract is working for you that you might not even realize. The first one is this, and it seems pretty simple, but not really when you think about it, because I get this question a lot. But your contract is going to basically tell you who your client is, who signed the contract. So typically, you are only going to be legally obligated to the actual person that has signed the contract, not necessarily the couple if there's a mom or a dad involved, not necessarily the rich uncle if that person is in fact paying. Only the person that is signing that contract is the person that you're going to be technically legally obligated to. Now, without splitting too many hairs, you do owe duties to the beneficiaries of the contract if the couple is not the one that signs, yada, yada, yada. But at the end of the day, we know from a broad standpoint who you are going to be listening to if there is a dispute amongst the couple and whoever is the person that actually signed the contract. So that, in a nutshell, is a pretty big deal. A lot of people get lost in the weeds on that. They say, well, you know, does the mom sign? Does the couple sign? At the end of the day, your client is the client is the person that signs that contract. Now, let me just say this. A practice pointer for you and your contract, if you're running into issues with, well, the mom is the client because she signed, but there's a disagreement between the couple or the rich uncle or whatever it is, adding what would be called a point of contact clause. In other words, in your contract, you can say, okay, mom is the one that signed and mom is the client. However, if there's any situation in which there needs to be a tiebreaker, you are nominating X person. It could be the mom or whoever, it doesn't matter. But you can say, this is the person that's going to have final authority, or this is the person that is going to be my only point of contact. So I'm not talking to 6 different people. So at the end of the day, your contract is setting forth who the person is that you're actually going to be obligated to listen to. And then there are ways to get around that if you need to. And the second way that your contract is working for you and you didn't realize it is actually dictating when the relationship, the legal relationship, begins. So oftentimes we live in a limbo or no man's land of sending a proposal, waiting for that proposal to come back. Maybe we're actually doing a little bit of work while we're waiting for the client to make up their mind, or we're still negotiating while we're doing walkthroughs or whatever it is. But typically, the contract is going to be the true, not necessarily definitive, but the best way to mark or indicate when the legal relationship actually begins. When does the work start or go from we're just talking to now it's on? So until you have that contract, sometimes it's difficult to understand where your obligations are, where your boundaries are, all that kind of stuff. But once you have that contract, that's a major hurdle that you've accomplished. Like now we have the beginnings of the actual legal relationship to one another. So a practice pointer with regard to the contract being the starting point is you can dictate with your proposal or with your contract acceptance language. In other words, when you pass that proposal to the client for their signature, you pass the draft of the contract for their signature, you can tell the client, no more work, or I'm not holding the date, or I will hold the date, or you only have 3 days to respond, or in order to respond, you have to give me the money and the signed contract. There are many, many, many options for you with regard to the obligations of that client to let you know, yes, let's start, let's get the date set, all that kind of stuff. You can be the master of the bargain. The third thing that your contract is doing for you, if nothing else, is defining the scope of work. So, it's easy to say that, well, I'm a DJ and I'm going to show up and I'm going to play music at a wedding and for this many hours, and at this location. But the contract actually helps us understand the gray areas. And what I mean by gray areas in the DJ example is, do you bring lights? Do you make sure that your equipment is available to guests for speeches or their own performances? Like maybe the niece of the groom plays violin. Are you obligated as the DJ to lend your equipment to a situation like that? So the contract is helping to expand the definition of your scope and what you are actually doing. It goes beyond just the basics and helps understand the obligations that you might have or the client might have and educate them on what is actually going to go down. So a practice pointer for that is to really make sure you've got a bullet point list, or it's indicated in some way in your contract, the outer limits of what you do. In other words, do you accept calls after 5 p.m.? Do you communicate every day of the week? These type of things. Do you require certain power requirements if you're a DJ, or do you have substitution policies if you're a florist? Things that might not necessarily be intuitive, address that in your contract in the scope of work, so your contract can be working for you even harder than it already is. And number 4, and finally, the contract is actually acting as a memorialization of the terms. In other words, if you're operating just on a handshake, then what you're doing is leaving it to each other's memories as to what was agreed to. So even at the end of the day, if nothing else, even if your contract is just literally date, time, the amount of money, where I need to show up, at least all that information is boiled down to a writing that can't be forgotten by imperfect human beings. So when you add more and more and more stuff, it's better that that's in a writing, because that's not something that the parties have to continually always remember. So the contract, if nothing else, acts as a record of what people can expect with that relationship. So at the end of the day, we know that your contract should have your solid liquidated damages clause. We know that your contract should have a force majeure clause or a COVID clause. Your contract should deal with limited liability, indemnification, all these things. But I just wanted to have one video highlighting just kind of the basics, like because some people might argue like, well, Rob, I take my money up front. I'm not worried about the liquidated damages clause. I've done this for 25 years. I don't care about the COVID issues or the force majeure. I always work it out. But even beyond these things, these 4 basic jobs or duties that the contract has to me is enough. Even if you have the most basic contract, it's better than nothing for those reasons. And so I hope that you found today's video somewhat enlightening, somewhat educational. If you did, please be sure to like and subscribe. Leave a comment down below. Is there anybody out there that is watching this video that operates without a contract? If so, how has that been for you? Have you had any blowback from that? I have had clients in the past who have operated for years and years and years without written contracts. And so some of them get by and it's okay. Some of them have had issues, and that's why they had to come to me. So leave a comment. Let's get a conversation going. New videos out every week at Wedding Industry Law on YouTube. They drop on Monday. And with that, folks, we will see you next time.